Different stakeholders are continuing to give their inputs into the Uganda People's Defence Forces Amendment Bill 2025 that was referred to the Committee of Legal and that of Defence by the Speaker of Parliament Anita Among. Lawyers from Jude Byamukama and Company Advocates have appeared before the joint committee chaired by the chairperson of the Legal Committee, Stephen Bakker, deputized by Wilson Kajwenge, the chairperson of the Defence and Committee, to give their inputs into the bill. Byamukama says the bill has some good provisions, but that a few clauses make it look bad. He adds that the bill does not incorporate a provision on firearms and explosives, emphasizing that making pistols a monopoly of defense may cause problems.
The basis of a military court, if it exists, was that there were a certain set of offenses that can only be committed if you are a military officer. For example, you refuse to attend parade. The general knows others. You refuse to attend parade in the morning. How do you get disciplined?
The schedule to the bill says pistols are ordinary monopoly of the defense forces. Mr. Chair, I submit that this could be a cause for problems. Innocent Ugandans who are licensed to carry firearms and who have firearms could find themselves being treated as subject to military law, when clearly they have done nothing unlawful per se.
The lawyer also proposed that jurisdiction of the General Court-Martial be restricted to cases under the UPDF Act and not those under the Penal Code. One of the members of the committee, General James Mugira, questioned this proposal.
And the parent law, the UPDF Act, have a criminal justice system built in them. The court-martial is part of the criminal justice system. And the Supreme Court in Kabazuguruka, contrary to the assumption out there in the public, did not say the court-martial cannot exist. The Supreme Court recognizes its existence, but as a specialized court.
Now, I want you to advise on situations where you would have a military personnel who has committed murder in an operational area, like in Somalia, and we have to try him.
I think, Council, that International Criminal Division can as well handle matters like General Mugira talked about, for example.
Under the UPDF Bill, Clause 177A expands the coverage of civilian cases to be tried in court-martial, which Byamukama says should be only applied in very limited and exceptional cases.
We could create a division in the High Court, just like we have a division in the High Court that handles corruption and other issues. And the reason was to detach the military from the administration of justice.
Clause 117A merely classifies certain offenses for the court-martial. The standard for trying civilians has not been demonstrated at all. This is because it does not exist within Uganda, and there is no justification for Clause 117A, given that ordinary civilian courts try far more serious offenses, such as terrorism and treason. This Clause 117A, Mr. Chair, ought to be deleted.
He also proposed that Clause 195 of the UPDF Bill be modified to guarantee security of tenure of a member of court-martial and division court-martial, at least 7 years, non-renewable.